overwhelmed, so I'm just.
Yeah, I can send you a little one. Okay, it was sent to your computer. Get back to you to the email or.
Yeah, okay, sounds good. If you'll just send me an email and I'll get back to that.
Yeah, send you your email.
So it says concurrent probation, but the other case is dismissed now. Just probation. Okay, Ms. Richardson, can you raise your right hand?
Yes, sir.
Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Can you state your full name and date of birth for me?
Alexis Richardson, 11/01/96.
Ms. Richardson, you are here in two different cases, but you're only pleading to one, right?
Yes, sir.
But I still have to go through them both. In 25 CF 1803, it's possession of a controlled substance, third-degree felony, punishable by up to 5 years in prison. Count 2 is possession of paraphernalia, first-degree misdemeanor, punishable by up to a year in county jail. Then you also have a brand-new case, 26 CF 377, petty theft, first-degree misdemeanor, possession of drug paraphernalia, first-degree misdemeanor, both, again, up to a year in county jail, and possession of controlled substance, third-degree felony, up to 5 years in prison as a maximum. Do you understand all that?
Yes, sir.
As far as what you're currently charged with. All right, I have a plea and sentencing agreement that says you're going to plead to the 377 case, and in return, the state's going to dismiss the 1803 case, the old case.
Yes, sir.
2 years of probation on the felony, credit for time served on the 2 misdemeanors. You're going to do a substance abuse evaluation, any recommended counseling, or comply with the Emerald Coast Life Center. It's going to be $515 court costs, $100 cost of prosecution, $100 PD fee, waive cost of supervision, do not return to the Dollar General, anti-theft course, restitution of $37.99, and it'll be a withhold of adjudication. Is that your understanding of the agreement?
Yes, sir.
Is that the state's agreement?
Yes, sir.
Okay. All right, have you gone over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand and sign it?
Yes, sir, I did.
And are you satisfied with your lawyer's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything other than the terms of the agreement I've just read?
No, sir.
You understand that by entering a plea, there won't be a trial of any kind.
Yes, sir.
You understand you're giving up your trial rights, which are on page 2 of that agreement that you signed.
Yes, sir.
And you understand that if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country. All right, and what is your plea in 26 CF 377? It's petty theft, possession of controlled substance, and possession of drug paraphernalia.
No contest.
Accept your no contest plea is freely, voluntarily, knowingly given. State have an announcement in 25 CF 1803.
Yes, the state will announce a null pros.
All right, and I'll process the entirety of that case. It's going to be a withhold of adjudication in the 377 case, 2 years of probation. On the felony, on the 2 misdemeanors, it's just credit for time served, so you're not on probation for those 2. Substance abuse evaluation, any recommended counseling, or comply with ECLC. $515 court costs, $100 cost of prosecution, $100 PD fee, waive cost of supervision. Do not go back to the Dollar General. You're to do an anti-theft course and pay restitution in the amount of $37.99. I'm assuming that's the Dollar General.
Yes, sir.
Anything that I've missed?
No, I'll submit a score sheet. She scores 18. Oh, you
I have a score sheet.
Okay, great.
And it shows 10.20 points, so this is the guideline sentence. Ms. Richardson, still think I need fingerprints because the petty theft is enhanceable, even on a withhold. So I need your fingerprints, then talk to probation, who's sitting there behind you, and then you have 30 days to appeal the judgment and the sentence of the court.
Yes, sir.
Thank you, Ms. Richardson.
Thank
Goodbye.
you.
Oh, right, then Macy, go the other way. I think Mr. Vega's done. Well, we'll see. It'll be the 4th time we've called him. Mr. Vega, come on up. Let's get you going.
Questions?
What is this?
It's the same terms. Okay, have you signed it?
Mr. Vega, can you raise your right hand?
Sir.
Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
State your full name and date of birth, please.
Vega, 102388, sir.
All right, you're here in 25 CF 1726, where you're charged with child neglect, a third-degree felony, punishable by up to 5 years in state prison. Do you understand that?
Yes, sir.
I've been given a plea and sentencing agreement that calls for you to plead to enter a plea, and you do the PTI, or pretrial intervention program. It'll involve withhold of adjudication. You'll be on it for 1 year. Waive cost of supervision, $667 court costs, $100 PD fee, $50 application fee. Attend and complete a parenting course. You're subject to no notice home inspections. Who would be doing those? Does PTI do that?
Don't know, Your Honor.
Okay, probation will do that. All right, so you have to do all those terms, Mr. Vega. If you complete those terms, your plea can be withdrawn and the case dismissed. However, if you fail to complete those, you can put your hand down, Mr. Vega.
Yes, sir.
If you fail to complete the terms of the PTI, then you can come back to court for sentencing. Because it's a third-degree felony, you could be sentenced up to 5 years in state prison, like I stated. Do you understand that? Is this what you want to do here today?
Yes, sir.
Can you
That's
turn
fine.
that microphone towards him a little
Yes,
bit?
sir. That's fine.
Okay, it's a lot harder to hear up here than with the microphone.
Touche.
All right, Mr. Vega, did you go over this agreement with your lawyer?
I did, yes, sir.
And did you sign and understand and sign it?
Yes, sir.
If you could take that back to probation so they can have the original. All right, and Mr. Vega, are you satisfied with your lawyer's representation in this case?
With the utmost respect to her and her profession, no, sir. Oh, no, sir.
You're not satisfied?
With all due respect. I think
Well,
she's just overbooked and undermanned. So we did the best what we had.
Hold on. What did you do? What did she fail to do in your case?
I think she was just too busy. I just
That's
think
not an answer to my question. What did she fail to do in your case because she's so busy?
I felt as if I did a lot of things and I kind of set myself up to a good situation, and I don't think she had enough time to put forth that towards this, because I remember one time we had 2 court cases ago, the whole courtroom was just her. And again, there are only limited resources and stuff like that, so I get it. I don't think I got the...
All right, Mr. Vega, I'm going to ask you this for a third time.
Yes, sir.
What did she fail to do in your case because she was so busy, in your opinion?
I felt like more could have been done.
What? I'm asking these questions because they're important. Because if we come back later, say, for example, you don't successfully complete this, and you come back for sentencing, and that
Right.
puts you in prison potentially. I'm not saying I'm going
Right,
to, but
understood.
that's a
Yes, sir.
possibility.
Right.
Then you could come back and say, well, my attorney didn't do a good job for me. And then we have to go through what's potentially, what's called a 3850 or ineffective assistance of counsel issue. So I need to know what you're claiming now, so when we get to that point, I know that you've told me already.
I don't
Complaining
have...
someone's busy isn't sufficient. Tell me what didn't happen in your case or what she did poorly in your case.
I felt she could have fought a lot harder. I felt like I had DCF and animal control, and a lot of people and parties that were involved had closed out the case, and I had them on 2-week intervals come in before the next court case and sign me off, and we're still in the same boat that we were in September, and I felt
So
bad.
you'd like to go to trial instead?
No, it's fine. We can take... This is fine right here.
It's not fine until we get to the point where I understand what you're saying she could have done differently, specifically.
Currently, right now, it reflects poorly on my background check, so I'm still treated like a felon, even though we're ongoing for the last 7 months. So it makes it really hard for me to get jobs on base.
How is that her fault?
I feel like I don't know I don't know the law as well as she does. So a lot of the stuff that we were able to resolve was from stuff that I kind of researched, found out right before we came up to the stand, and then you would see me go back and we try to, work it out.
Yeah, that happens sometimes.
Understood.
So what didn't she do? What have you asked her to do that she hasn't done?
I mean, I called from Tuesday to Friday, and I never got a call back all last week because I was trying to get the terms, and then we had to wait 2 hours just to really discuss the terms that should have been discussed before we got here. For example, it's little things, but it was that over a course
How
of
has that
stuff.
changed your case?
I feel I don't know the law as well as she does.
I understand that.
Right. So I felt maybe it could have went better for me. I don't know. I don't
So you're just speculating, you think it could have gone better if she wasn't as busy?
I do.
But
I
you
don't
don't
think
have
I had her
anything
full.
specific that she's failed to do for you that you've asked her to do?
I don't believe I had her full time and attention because I think she had too many people.
Every lawyer has a lot of people,
Right,
even
right.
ones you privately retain.
Yes, sir.
But what you have to tell me is, what specifically did she fail to do on your behalf? Because I'm getting to the point where I'm not going to accept this plea.
Understood. Fight harder. That's all.
What does that mean?
I don't know what she could have got. I don't know what could have got reduced.
So you're
or-
just upset with what the state's plea offer is? You think it should be better, and so therefore it's her fault?
I feel like we could have had a better case. I felt like I did a lot of things to put us in a good situation, and it's still where it was in September.
You still haven't given me any specific, any detail, any instance of what's gone wrong, other than you just want better.
I don't know enough about the law to go back and forth.
That's my point.
Right.
So you're
I'm
just speculating, right?
We can go off that. Yes, sir.
No, that's not a proper answer. Frankly, Mr. Vega, I'm not sure what your issue is here. But if you're not satisfied, you can pursue that through something called a Nelson hearing to say, my attorney didn't do certain things. We can have a hearing on that. But when you break it out in the middle of a plea colloquy, it shuts me down.
I see that. Yes, sir.
All right. So what would you like to do? Do you want to file for a Nelson inquiry where I can determine whether or not Ms. Rivers has failed to do something for you any further? Or do you want to set your case for trial? What would you like to do? Do you want to go hire your own lawyer?
I don't think I have the funds. That's what I was saying. It still reflects, when I do background checks with base, it still reflects as that. So even if I have the experience, first thing they check is background check, and that's what I was trying to avoid, because even if I did the year program and it fell off, I don't know if this case could get, or this charge can get expunged. So every background check that I do with the base or anyone outside the base, deep background checks, it's still going to reflect this.
Okay, so your options are to not accept this then, if that's what your concern is.
And I said, would it, I don't know, I guess the repercussions of that and to her and to me, and that's,
You're the one that's complaining that she didn't do something, but when I ask you what your
Right.
complaints are, all you say is, you wish it was better.
all around, yes, sir.
Say again?
I said all around, yes, sir.
Okay, well, then I'm not
But
going to
we can-
accept your
I can
plea.
accept
Mr.
the-
Vega,
Sir,
you're free to file your Nelson inquiry. You're free to hire someone else, or you're free to set your case for trial. But if you think that she's done a poor job for you, I can't accept your plea.
I think she's done the best she could do. You know,
That's not the
I don't know if I'll get anything better though with the current financial situation.
okay.
You know what I'm saying? So that's why I was gonna sign the agreement, because I don't know.
Well, it sounds like you're just doing it because you don't have any other options.
Yes, sir.
But that hasn't explained to me what she's done wrong.
I
So
I
this is
think-
what I'm going to do. I'm not accepting your plea. I'm going to give you a new court date. Y'all can have a discussion about this and how you want to proceed.
Okay, yes, sir.
But I can't have this go on and on where you keep saying it's her fault somehow that your case isn't better. When what the result, and I don't know the facts of the case, but
Right.
the issue is, you've got a program that's going to ultimately lead to the dismissal of your case, and you're saying that's not good enough. So you need to tell her what you want her to do so she can do her job better, as you say,
Right,
by telling her specifically what you need her to do.
right. That's fine.
All right.
Um,
Anything else, Mr. Vega?
if the year passes with the charge in itself, is it still able to come off of my record after
I can't
that?
tell you that, sir.
Got you. That was it.
I mean, I can tell you what the court system thinks about it, but what
Yes, sir.
the difference is, and it sounds like you've been explained this thoroughly because you know exactly what the issue is. Going on base, a federal military installation,
Sir.
has a whole different set of rules than the criminal courts do in the state of Florida.
Yes, sir.
So what she's explained to you, it sounds like, is you're going to have an issue with this, right?
Right, I was.
Because the federal government treats withholds of adjudication like they're convictions for the most part. And so even with a pretrial intervention agreement, that's what the federal government may do. But that's
Right.
not something we can change.
Right. I didn't know if being a veteran it helped or hurt or anything, so I understand. Yes, sir.
I'm not sure why it would.
Well, I remember they had mentioned Veterans Court with Mr. Terry Thompson the last time we were here, I think last week, but I don't know if that is even applicable.
Did you ask Ms. Rivers to look into Veterans Court for you?
Oh, no, sir, but we brought up that I was a veteran on the first the very first.
Veterans Court isn't you get some advantage because you're a veteran.
Yes, sir.
Veterans Court is you go through a whole different program that's focused on the issues that veterans face as they either exit their service or retire from their service. And it's usually a lot of the things that are based on service-related disabilities or concerns.
Yes, sir.
And that's what it focused on. You know, a lot of our veterans come back, and I can tell you this because I represented numerous people who went through the Veterans Court when I was a criminal defense lawyer. And a lot of it's about, you know, it's people who have PTSD, people who have head injuries, things like that. That's what Veterans Court focuses on.
Yes, sir.
It's not just some sort of advantage because you served in the military.
Right. It's the first time I heard it. The last.
Okay, so
Yes,
would
sir.
you like her to look into that for you for some reason?
Yes, we can look into a couple of things to where
Okay.
this doesn't happen in the next go.
What doesn't happen?
Just we have this conversation. I feel bad that we have this long drawn out conversation. So
It happens. It's my job to make sure everyone knows what they're doing when they enter a plea. You've heard me question people all morning to make sure they know, and when someone gives me an answer that's different from what I'm expecting,
yes, sir.
I have to make sure I understand what your concerns are. You've
Yes,
now
sir.
expressed those. I'm not quite sure I understand what you think she's done wrong, but it sounds like you want her to do different things now.
Yes, sir.
All right, we'll see you back on April 27th at 1 o'clock for your next pretrial conference. I would suggest you stay in touch with Ms. Rivers.
Of course.
So you can discuss those things, maybe
Yes,
even
sir.
do it in writing if you're concerned that she's not listening to you fast enough.
Okay, yes, sir.
I will point out that Ms. Rivers is in a 1-week-long murder trial next
Yeah,
week, so
I
make
heard
sure
that.
that she understands that she can't just be on the phone all day.
Of course.
All right, thank you, Mr. Vega. Have a good day.
You too. Thank you so much.
Your Honor, she just needs a moment to sign the agreement. Okay.
Yes.
If I, for the score sheets, I don't have time to go back to the office, should I print those and bring them back to you, or can I email them?
I think
to
it'd be
you?
better because I have to fill out a portion of it, right? So if you
Right.
give it to me, I have to print it out
Yeah,
so I can mark the boxes and then then scan it back in the system. So if you just bring me the paper ones,
Yes.
I can sign them and turn them in.
okay, I'm gonna have my assistant bring them over, I just wanted to make
Perfect.
sure I was doing it right. Thank you.
Can I approach with one score
Yes.
sheet from this morning?
Okay. Yeah. All right, so. There we go. Right there.
How much
3, 2.
probation did Lee get? 1 year? Two.
Your Honor, if I could.
We're missing a page.
Here, defendant.
Yep.
Ms. Roberts, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Is going to be a guideline sentence that we do?
Yes, Your Honor.
Make sure we get them. All right, Ms. Roberts, can you state your full name and date of birth, please?
Ashley Nicole Roberts in 92986.
Ms. Roberts, you're here on two cases. You've got 24 CF 2909, which is a VOP, and then 25 CF 1923, possession of a controlled substance. That's a third-degree felony and punishable by up to 5 years in state prison. Do you understand that?
Sir.
We've got a plea and sentencing agreement that would call for you to admit your violation of probation in 24 CF 2909, and then plead no contest in 25 CF 1923. In the VOP, it'd be adjudication of guilt, $100 cost of prosecution, $100 PD fee, and a $50 application fee. Revoke and terminate your probation and credit for time served. And 25 CF 1923 would be an adjudication of guilt, $615 court costs, $100 cost of prosecution, and credit for time served. Is that what you want to do here today? Is that what you want to do?
Yes, sir. Yes, Your
Okay.
Honor. Sorry. Absolutely.
All right, and have you had enough time to go over this with your lawyer?
Yes, sir.
And
Yes,
do
Your
you
Honor.
understand and sign the agreement?
I do. I do understand, yes.
Okay. And are you satisfied with your lawyer's advice and representation in this case?
Yes.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, Your Honor.
Are you currently suffering from any mental health issues?
No.
Okay. Has anyone forced, pressured, or threatened you in any way to enter this plea?
Not at all.
Has anyone promised you anything other than the terms of the agreement I just read?
No, Your Honor.
And do you understand that on the VOP, if you admit that you violated your probation, there won't be a hearing where the state would have to prove how you violated your probation?
Yes.
And do you understand if you enter a no contest plea on the new case, there won't be a trial of any kind?
Yes.
Do you understand you're giving up your trial rights, which are on page 2 of that agreement you signed?
Yes.
And do you understand if you're not a U.S. citizen that you could be deported or excluded from the country based on this?
Yes, Your Honor, I understand that.
Okay. And Ms. Roberts, what is your plea to the violation of probation? Are you admitting or denying that?
Admitting.
All right, I'll accept your admission as freely, voluntarily, knowingly given. 25 CF 1923, what is your plea to the possession of controlled substance?
No contest.
Accept your no contest plea as freely, voluntarily, knowingly given. In 24 CF 2909, adjudication of guilt, $100 cost of prosecution, $100 PD fee, $50 application fee. Revoke and terminate your probation, credit for time served. In 25 CF 1923, it's going to be adjudication of guilt, $615 court cost, $100 cost of prosecution, credit for time served. I will need your fingerprints, Ms. Roberts, and then you have 30 days to appeal.
Thank you so much.
Thank you.
Best one.
Okay, all right. Thank you so much.
Your Honor, this is Jeremy Williams before the court on 25 CF 702. If the court will recall, I did adopt his bond motion the other week. So we're here today for the bond motion, and we are currently set for trial. To address the bond motion first, Your Honor, he has previously assessed a cash professional bond in the amount of $2,500. He's been in jail for close to a year. He's been unable to post that bond. I do need to take some testimony from him, to establish the remaining criteria. Bond hearing.
bond modification last week?
It was still listed on the clerk's site as having it today, so.
I think it was, but then we addressed it last week because, well, that's my memory of it. And then I just looked up the clerk's minute sheet from the 26th, which was last Thursday. Bond modifications was there tonight.
This case was set for a trial, and the state did indicate to us that they would have an offer. Wouldn't be credit time served, but it would be a different type of offer. I have conveyed that offer to Mr. Williams. He is at this time requesting that his case be taken off the trial docket and allow us the opportunities to try to depose the owner of the property in this case. And so at this time, we are requesting to take this off the trial docket, put this back on the regular pretrial conference docket.
State's opinion, one yours, fine.
Mr. Sprout, I had to step out, but what was the?
Well, didn't he say he would object to a
Yes,
continuance?
he did.
When I briefly brought up to see what the trial docket was gonna look like?
Yes, Your Honor, he did.
If she was outside on the phone, I can run and get him.
Yeah, he said he objects to it.
Someone could.
Sorry, Judge, I was working out one of our trials.
Oh, that's fine, but this is the case, I think you objected to a continuance when we
Yes.
talked about it briefly.
Yes, this is
Williams,
Mr. Williams.
25 CF 702.
Yes, the defense at our last court date said they were ready for trial. So the state's ready for trial. We sent out subs.
Anything else? Motion's granted. You would like to put it on April 29th?
Yes, Your Honor.
April 29th at 9 o'clock for pretrial conference. See you back on that date, Mr. Williams.
Mhm.
No, it's 24, 17,
Your Honor, this is Gary Wright before the court on 25 CF 1812.
Okay.
He is currently set for trial, and he would like to remain set for trial, yes?
Just-
Yes, he'd like to remain set for trial, Your Honor.
You ready for trial?
State's ready for trial.
So what we're gonna have to try to do is pick that second jury on this one, on this coming Monday, and then set it for the second week, because not only am I not available that first week, neither are you, because we're both being the same murder trial. Any issues with doing it that way?
No, Your Honor.
It's unfortunate, I don't have anyone, I don't have any other way of doing it, since we don't have jurors for the second week. So we'll pick them for the first Monday and make sure they all know in advance that the trial's gonna be the second Monday. It's not something I'm a fan of, but I don't think we have any other options. Just because the way things worked out, that I can try to get a substitute judge, but I can't substitute in someone for you, Ms. Rivers. So we'll keep them on the trial docket. Let's put them on Friday the 6th, just to make sure everything's still ready to go. And we'll see you back on that date, Mr. Ray.
Yes, sir.
Okay.
Thank you.
Oh, how many jurors do you think we need on Mr. Wright? 2030? If that.
If that, Judge, 2030.
Just because of the week delay, it might have some people that won't work for, but I think that should be enough.
And I should have either returns or not by Friday.
All right, Mr. Maddox.
Yes, Your Honor, this is Ms. Guzman Arredondo before the court in several cases. 25 CF 2073, or well, I guess it's just 25 CF 20. Several cases, I'll say, Your Honor. We had passed her today to see if we could work out a resolution. The state was looking over the score sheet, is still looking over the score sheet. As soon as I get that, I'll go over it with Ms. Guzman. We very well may still have a resolution, though, Your Honor. Would you mind putting this case on 3-6 for possible resolution?
That's fine with the state, it's just,
I don't want to get in the habit of just putting people on court dates hoping something happens, as
Yes, Your
opposed to just, if something gets worked out, then you put them on there. I'll do it this time, but I just, because it's not us. I mean, we spend, no offense, Ms. Guzman Arredondo, like, it's transporting her over here just to come and find out nothing's changed and then having to transport her back, and
No, you're completely right, Your Honor. That's fine.
I'm not completely right. I'm open to suggestions. But I just think it's a lot of effort when nothing has been worked out. But then again, you can always add someone to a docket to resolve it.
Yes, Your Honor.
So let's put her on March 6th, and if y'all can resolve it, great. Otherwise, she'll have to be continued from there.
Go ahead.
No, you just did it.
You sure?
Yeah, that's right.
Oh,
Okay.
well, yeah. No, I respect that. I understand.
Okay.
All right. All right, thank you, Your Honor.
Thank you.
Your Honor, this is Kristen Barnes. I talked with the state this morning. Ms. Barnes scores in the neighborhood of 16 months in the Department of Corrections. 16, yes. We're not in a position to resolve this today. I would ask the court to continue this to the April 29th docket. I have discussed with Ms. Barnes filing a motion to reinstate bond, and so I'll go to the jail for that, get that filed and set for a hearing. This time it's not ready for resolution.
These are both new law violation type cases.
We were just appointed, yeah, that's correct, they are. We were just appointed to both of these. So I don't have discovery in them yet, so.
So 4/29, 9 o'clock.
Perfect, all right.
Mr. Clinton, did you talk to Brittany Fowler today?
I did, I talked to her out in the hall.
Told her to
so-
try and track you down when
Yep.
you weren't talking to someone else.
She got me out in the hall and I gave her a card and the whole 9 yards. It's your motion. Your Honor, I was just handing Ms. Teresa Phillips a copy of the motion to suppress that was filed on Friday. If we could continue this to the April 29th docket, we'll get that motion noticed.
What was the motion?
It's a motion to suppress.
Any objection from the state on that?
No objection, but can I have the case number, please?
Here, it's 19 CF 1590.
1592.
Yep. All right, I'll come talk to you, okay? Okay, yep. Your Honor, this is Mr. Kelvin Ford. I did speak with Mr. Ford this morning. He is not wanting to file a speedy demand at this time. I would ask the court to continue Mr. Ford's cases to the April 29th docket. I did advise Mr. Ford that I will try to get a statement from the alleged violation. The reason why he's so invested in trying to get this resolved as quick as possible is his mother is trying to move to India, help her try to get. Why sometimes he gets a little worked up, but we could continue this to the April 29th docket. We're working on a resolution as fast as we can.
All right, Mr. Ford, we'll see you back on April 29th at 9 o'clock, but if they come to a resolution sooner than that, we can bring you back in earlier for an early plea if that's what ends up resolving it.
Yes, sir.
All right. Thank you.
Come on. All right, come on. Your Honor, this is Jeffrey Moore. This is a situation we were in the middle of a plea colloquy last week on a time-served type situation, and the state advised the court that it had to withdraw the offer. I was paying attention 10 minutes ago, 5 minutes ago. Remember what Mr. Maddox was talking about, and how the court says, I don't want speculating on something's going to happen. I did talk with Mr.
I'm
Moore.
not shutting it down forever. I just, because if someone's on today's docket, clear continue, that means that they're not set for trial, which is what people are supposed to be for today. And we put on another one on Friday for the same reason, then we just keep kicking the can. It's a lot of effort for you all, me, court security, jail transport people, just to say, nope, still haven't figured it out, as opposed to just adding them later.
Sure.
I'm kind of thinking out loud a little bit here, but just so not everyone has to do that until you know you've got it figured out for sure.
What I had talked with Mr. Moore about over the lunch break, basically, was seeing if we could get a motion to reinstate or set bond, some sort of a bond motion here, given what last week. Mr. Moore is frustrated about what happened. Then in between that conversation I had with him and the court's statements to Mr. Maddox, I was going to ask the court to bring Mr. Moore back for sure on this coming Friday. However, I have told Mr. Moore I will go see him either tomorrow or Wednesday. I have a juvenile docket this Thursday. I have to be up here out of some juveniles. I will go to the jail and get bond information for Mr. Moore. Given what the court, statements the court had just made, I don't want to just say, just put Mr. Moore on for Friday, just in case. We are still waiting to get an answer from the state. The state may still propose that plea offer. My understanding is Ms. Flowers is waiting to hear back from a supervisor at the state attorney's office on whether or not the plea that had been discussed last week. So,
Given that situation, I don't have a problem putting them on for Friday.
okay.
Since, again, it was halfway through the plea when it was kind of shut down, and if it can go back, whatever y'all decide, but.
If we can put
What
him
I
on.
said to Mr. Maddox was just kind of a, maybe we shouldn't be doing it this way, because it's a lot of effort unless it's figured out. But this is, your particular case, your set of facts is a little bit different.
Okay, if we can, yeah, we'll leave him on for Friday. If I have to come up here, I think I have to come up here tomorrow I have one misdemeanor with Judge Ward tomorrow on an arraignment. So if I have to be up here tomorrow, I will see him tomorrow and I'll get the bond motion filed tomorrow. If not, then I will see him on Wednesday and I'll get the bond motion filed on Wednesday. But we'll have him back in court on Friday. I'll see you.
Talk to him this afternoon while you're here.
I actually have to get down, so a long story, but I will talk to him and we'll get the bond motion filed. Matter of fact, yeah, I'm gonna just get you bond. And then I won't see you before. So we'll have him back on Friday and I'm just gonna get the bond motion, the bond information real quick. So I'll get that bond motion filed tomorrow, Your Honor. Okay?
All right, so we're gonna put him on for Friday,
Clear continue, yes, Your Honor.
March 6th, 9 o'clock, clear.
That's all I have, if I may be excused.
Your Honor, there was one case that I think we still needed to address. Clerks had made us aware of. That would be Tyrone White. The one where we had gotten a message with a phone number Someone had dropped it off saying that Mr. White was in a nursing home in Pensacola. No name of the nursing home or anything such as that, just a phone number. I have tried, it was only twice, Your Honor, but I did try 2 different times to call. I was not able to leave any type of message, and that's as that. There was no voicemail to be able to leave a voicemail.
Was he not in custody?
No, Your Honor, he's the one who was.
I remember who you're talking, I just couldn't remember if he was in custody, because the concern is basically where he's gonna go. I mean, if you're agreeing he wasn't in custody, it's fine.
Your Honor, request to continue the case and give my assistant a chance to reach out some more.
The state would request it, yes.
I don't know if he has a bondsman.
I'll do is, keep his set bond at first appearance. Any explanation as to where he ended up. That was, I don't know, 8 weeks.
Your Honor, this is Mr. Boykin before the court in 25 CF 1524 and 25 CF 1525. Your Honor, the only outstanding issue, as I advised the court last time we were here, is the jail credit issue. I did reach out to the Covington County Jail over in Alabama. They told me multiple times I was going to have the paperwork today. Unfortunately, I don't have it, but I did speak to 3 different people who confirmed the dates he was there, confirmed the charge he was being held on. The dates that I have are from 7/3/25 to 7/22/25, and he was awaiting transportation on a fugitive from justice charge relating solely to the Florida charges. So that's all he was being held on. If the court would be inclined to award that credit with the proffer that I've made, then that's fine. But otherwise, Your Honor, I do have his signed plea. He just wanted to make sure that if that credit was something that the court would be inclined to.
What were the dates again?
7/3/25, so July 3rd of 2025 to July 22nd of 2025. That's when he got to our jail, Your Honor. Yes, Your Honor. If the court would award that, then we're prepared to enter the plea. If not, and it would prefer paperwork, which I completely understand, I just need to track down that paperwork is all that remains out.
What's the plea?
5 years DOC.
I'd rather have the paperwork given that situation. It's one
Sure.
thing if it's stipulated, but, if I start, no offense, Mr. Manis, if I start taking the word of every attorney who says, yeah, he's got more time from another place, can you give him credit for it?
Yeah.
Without paperwork, I think it's a problem.
No offense taken. Yes, Your Honor. But I've been told, I should have had it today. I've given 3 different people my email. I've talked to everyone I can talk to over there. I even emailed the court liaison. But again, I do anticipate having it by Friday. If the court wants to go ahead and set Mr. Boykin for Friday, that would be fine. If not, and I get the paperwork, I'll add him to the docket at the court's earliest convenience to resolve it.
You can add them for March 6th, Friday. But it's an idea if the papers come in.
Yes,
in
if
the
I-
meantime.
Yes, Your Honor. If I don't have it,
has
I'll.
a chance to look at it, you know, if Mr. Sprouse sees it, is it yours or Ms. Flowers? You have a chance to take a look at it and verify it in some way. But
It was, it's Miss Leone's case, Your Honor.
Yes, and that was her understanding that it would be resolved on Friday.
And we will take a look at it on Friday, Mr. Boykin. I'm trying to get it done for you, but I gotta have paperwork.
No, trying to
Your
get you the
lawyer's
extra
doing everything
credit,
he
so. Yeah. Yeah, I mean, the only thing that would change would be you get more credit, so that's good. Yes, sir. Thank you. Thank you, Your Honor. I'll reach out again this afternoon. Your Honor, this is Mr. Brand before the court in 25 CF 848. The state did get an opportunity to look over the case. They did make a revised offer, although substantially different, I'll say, than what we were hoping for. So I would ask for a full cycle continuance, Your Honor, to the April pretrial docket. The state had no objection to this continuance. I do know this case is starting to get on the older side, Your Honor.
Be a year old when we come back.
Yes, I have taken the depositions that I need to take. I am still awaiting a mitigation report from Dr. McDonald. That may or may not have an impact, but we're starting to get to that point, Your Honor, and I'll start getting it in a clear trial type situation here soon.
All right. I would expect it to be in that situation next time around unless it's a situation where you can't get the evaluation done.
Understood.
April 29th, 9 o'clock.
Thank you, Your Honor. Your Honor, this is Ms. Forrest before the court in 25 CF 1573. I did go over the specifics of the state's offer again with Mr. Sprouse, and then I relayed that to Ms. Forrest. It is a clear continuance situation, Your Honor, so I would ask that we continue the case with the expectation that we could potentially try the case if we need to next cycle.
Without objection.
So you still need to do a depo, right?
I may need to take depositions of the officers, but both of the alleged victims in the case, and excluding the child, have been deposed, so I have a pretty good idea of what we're working with here. The only reason I would take depositions of the officers is if I talk to Ms. Forrest and something's not on body camera that she's expecting to be there or something like that.
So I would suggest that just it's done for next time.
Yes, Your Honor.
Have her trial if that's what she wants to do. Otherwise, 429, not that much.
That's understood. All right, Ms. Forrest. Yep, should be. Thank you, Your Honor. May I be excused?
Oh, hold on. Who do you have?
Dunmore was null pros at the previous court date. That's indicated in the minute sheet. Durham was previously continued to April 27th. We are going to set depositions in that case, Your Honor. But both of those are indicated in the minute sheet from the last pretrial.
Dismiss the case on Moore. Supposed to be set April 27th.
Yes, Your Honor.
It'll be 1 o'clock. That's what it says.
This is Ronald Wayne Allen, 21 CF 967. My understanding is that we're looking for a status update on the state's evaluation.
That's correct. We reached out February 25th, and Dr. McDonald's assistant said that Dr. McDonald would let us know when the evaluation is going to happen. It's not going to happen this month, is what was relayed to us.
We talked about this already.
Yes, I mentioned it out of turn. I didn't know if Mr. Allen was actually on premise. I do have the
I also
email
don't
if Your
think I
Honor
was
would
at
like to
the
see it.
podium, so.
I remember you showing me that from the, I don't need to see it. All right, so 429, 9 o'clock.
Thank you, Judge.
Appreciate it.
Judge, I'm going to bring the
Back up.
plea agreement back.
All right. Mr. Holston, I already swore you in. We've already talked about this.
Yes, sir.
I feel like I have to ask this. What are we here for today?
We're here to, about the, battery and, a old charge or something that I thought I had that had been dismissed already and, resisting arrest, sir.
So it's aggravated battery. The first
It-
degree, aggravated battery with great bodily harm, which means it's punishable by up to 30 years in prison. You understand that? You understand that, Mr.
Yes, sir.
Holston?
Yes, sir.
Okay, I'm asking you questions and
Yes,
you're
sir, I
just,
understand, but I didn't know you want me to cut you off or what?
you didn't cut me, I asked you a question.
I'm not used to this kind of
I understand.
procedures and stuff. I'm not.
Okay, well then just listen to what I'm asking you and then answer and we'll get through it.
All right.
But the problem was, when I went through a lot of this already, you got to the end, you just turned to your lawyer and said, what are we here for? And I was a little concerned that you're not quite sure what's going on.
I was kind of like this. I'm not familiar with these kind of procedures.
All right, well then, just answer the questions and we'll get through it.
All right.
all right.
Yes, sir.
Mr. Holston, I've already sworn you in. Again, you're here in 25 CF 2202. You're currently charged with
Yes, sir.
aggravated battery with great bodily harm, first-degree felony, so it's punishable by up to 30 years in prison. Count 2 is a violation of your pretrial release, first-degree misdemeanor. Maximum is a year in county jail. And count 3, resisting arrest without violence, which is also a first-degree misdemeanor and punishable by a year in county jail. Do you understand all of that?
Yes, sir.
Okay. And I've been given a plea agreement that calls for you to plead to just the resisting charge, the misdemeanor.
Yes, sir.
The state's going to dismiss the aggravated battery and the violation of pretrial release. And then it'd be an adjudication of guilt, time served, $270 in court costs, and $100 in PD fees, and I'll give you some time to pay that. Is that what you want to do here today?
Yes, sir.
All right. Now, have you gone over this agreement with your lawyer?
Yes, sir.
Did you understand it?
Yes, sir.
Did you sign it?
Not yet. That I know of.
It's on there.
Did I?
You
Yes.
signed it when
Is
you
that-
came out before, I guess.
Okay. Sir.
All right, that's your signature on there? There's a number, well, hold on. It seems like Mr. Williams, you may have signed with his spot and then crossed it off, and so there's not really a signature there. But your signature is kind of like mine, there's not a whole lot of legible letters in it. I think that's all of us. After
What the X
enough
at?
years to do that, your signature just becomes a bunch of squiggles. I sometimes joke, I still have it in a box somewhere. With my first day as a state attorney, they gave us like a stamp. They had to make our signature on it, and you can read every single letter of my signature on that stamp. And I don't think you can read one now. So it's just 22 years of signing your name 100 times a day. All right, Mr. Holston, now have you signed it?
Yes, sir.
Yes, sir. You did it right in front of me in a red pen, so I know it's yours. Perfect. All right. Now, Mr. Holston, are you satisfied with your attorney's work on your case?
Satisfied, sir.
Okay. And are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
You understand if you enter this plea, there won't be a trial.
Yes, sir.
And you're giving up your trial rights, which are on the second page of that agreement you signed.
Yes, sir.
And I went through them with you earlier today too, right?
Yes, sir.
And you understood all those?
Yes, sir.
Okay. And do you understand if you're not a U.S. citizen that this could lead to your deportation from the country?
Yes, sir.
All right. And what is your plea to the resisting without violence, a first-degree misdemeanor?
No contact.
Okay, I'll accept your no contest plea as freely, voluntarily, knowingly given. State have an announcement on counts 1 and 2.
Say that again, sir.
Oh, he's asking the prosecutor. a question.
Does the state have an announcement on counts 1 and 2?
Sorry, Judge. Yes, we dismiss the case. The 2 counts for plea
The
to.
AGBAT and the violation of pretrial release?
For a plea to resisting arrest without violence.
All right, on the resisting, it's going to be an adjudication of guilt, time served, $270 in court costs, $100 PD fee. Mr. Holston, I'm going to give you 90 days to either pay those fees or set up a payment plan. Otherwise, it's going to be a judgment against you, and they can suspend your driver's license. So make sure to get that set
So
up.
that's a total of how much?
$370,
370?
yeah.
All right,
And you can
so
set
I-
up a payment plan with the clerk's office on the first floor.
Yes, sir.
All right, thank you, sir. I do not need your fingerprints. You have 30 days to appeal.
Thank you, sir.
Thank you,
Mr.
Judge.
Wilson. Have a great day.
Good luck to you. No problem. Glad to help. Okay. Mr. Huertes, let me get your signature here, sir. And in writing, everybody will. All right.
Can you raise your right hand, sir? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Sure.
Can you state your full name and date of birth, please?
Michael A. Huertes, 31381.
All right, Mr. Huertes, you're here in 25 CF 2493, where you're charged with a constructive possession, what the CONST stands for, constructive possession of ammunition or electric weapon by a convicted felon or firearm. It's a second-degree felony punishable by up to 15 years in state prison. Count 2 is possession of paraphernalia, first-degree misdemeanor punishable by a year in county jail. Counts 3 and 4, both third-degree felonies punishable up to 5 years, and that's tampering with evidence and possession of a controlled substance. Do you understand your current charges, Mr. Huertes? I've been handed a plea and sentencing agreement that would have you plea as charged. On the felony counts, it's being an adjudication of guilt, 11 months, 29 days in the county jail, credit for time served. $615 court costs, $150 PD fee. That's to run concurrently across all the felony counts, which is 1, 3, and 4. On the misdemeanor count, adjudication, time served, concurrent. That's 1129 for that one too. Wouldn't have really changed anything, but
I think it's a second.
paraphernalia? Huh?
No, I'm sorry, I
Doesn't
did
matter.
one 5 minutes ago on a DWLS.
Well, you just changed everything too, and I mean, it sounds like y'all worked this out today, right?
Yes, sir.
So, not a big deal. I think you were supposed to do probation, that's why, never mind. Doesn't need explanation. All right, Mr. Huertes, is that what you want to do today?
1129, yeah.
Yes, sir. Okay. All right, have you gone over this agreement with your lawyer?
Sure.
Do you need more time to do so? All right, did you sign it because you understood it? And are you satisfied with your lawyer's advice and representation? Are you currently under the influence of any alcohol, drugs, or controlled
No,
substances?
sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you to enter this plea? Has anyone promised you anything in
No, sir.
return? Hold on. Has anyone promised you anything other than the terms of the agreement I've just read? Okay. Do you understand by entering a plea, there won't be a trial of any kind? And do you understand you're giving up your trial rights, which are on page 2 of that agreement you signed? And do you understand if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country? All right, and what is your plea as charged?
No contest.
Accept your no contest plea as freely, voluntarily, knowingly given. The adjudication of guilt, 11 months, 29 days, county jail, credit for time served, $615 court costs, $150 public defender fee. Those are concurrent across all counts. And it'll give you 90 days from your release from jail, Mr. Huertes, to set up a payment plan or pay off your court costs. That way, it's not a civil lien. It could potentially turn into a driver's license suspension for you. So make sure you take care of that when you get out. I do need your fingerprints, Mr. Huertes, and then you have 30 days to appeal the judgment and sentence of the court. This is a guideline sentence as he scored 37.10 points. Fingerprints, then you're good to go, Mr.
All right, sir,
Huertes.
good
Thank
luck.
you.
Over here. It's a mirror image in this courtroom with the
Yeah.
other one.
Sorry.
All right, Judge, we've got a written plea agreement. And this just needs your signature. It's going to be for some dismissals and then 10 months. Oh, I'll do it for you.
Thank you. Mr. Hutto, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Please state your full name and date of birth, please.
Kelly Lee Hutto, 10/20/1980.
All right, Mr. Hutto, you're here in two cases, 24 CF 1708, where you're charged with possession of controlled substance, third-degree felony punishable by up to 5 years in the state prison. Driving license suspended, second-degree misdemeanor, maximum 60 days jail. Possession of paraphernalia, first-degree misdemeanor, 1-year county jail maximum. Possession of a stolen catalytic converter, third-degree felony punishable by up to 5 years in prison. And then in 24 CF 1709, fleeing and attempting to elude third-degree felony, 5 years in prison max. Do you understand all that?
Yes, sir.
All right. I've been handed a plea and sentencing agreement that would have you plea as charged in the 1708 case. That's the possession, driving on suspended paraphernalia and catalytic converter case. In return, the state's going to dismiss the 1709 case, the fleeing to elude. And it'll be 10 months county jail, credit for time served, 615 court costs, 150 PD fee. That'll be concurrent. The second-degree misdemeanor driving suspended is only going to be 60 days because that's the max. So I can't sentence you to more than the max, even if it's concurrent. Do you understand all that, sir?
Yes, sir.
Is that what you want to do here today?
Yes, sir.
Did you have enough time to go over this agreement with your lawyer?
Yes, sir.
And did you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
You have a score sheet, or is that coming my way?
I have a bunch of score sheets, but not this one, because we figured it out after, my assistant brought these over, but he does score it around 34 points.
34 points.
Yeah, points.
So this is a guideline sentence?
Correct.
Okay. All right, Mr. Hutto, are you satisfied with your lawyer's advice and representation?
Yes, sir.
And are you currently under the influence of alcohol, drugs, or controlled substances? Are you currently suffering from any mental health issues?
Yes, sir.
Has anyone forced, pressured, or threatened you to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
And you understand there won't be a trial of any kind?
Sir.
And you understand you're giving up your trial rights, which are on page 2 of the agreement you signed?
Yes, sir.
You understand if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country? All right, and what is your plea as charged in the 1708 case? Accept your no contest plea to the possession of controlled substance, driver license suspended, possession of paraphernalia, and stolen catalytic converter as freely, voluntarily, knowingly given. As to the 1709 case, state?
That the state would null pros.
Null pros, 1709. All right, so on the 1708 case, 10 months county jail, concurrent across all counts, 615 court costs, $150 PD fee. Count 2 is the driver was suspended, that's only 60 days county jail on that one, also to be concurrent. This is the guideline sentence. Mr. Hutto, I will need your fingerprints, and then you have 30 days to appeal the judgment and sentence.
Yeah.
Oh, 6:48 court call. Oh, because there was traffic. 6:48.
Judge, the next one I have is Henry Jackson. Come stand right over here, Mr. Jackson. It's case number 2025 CF 1754. Judge, a null pros was filed on this, I think, yesterday, but there was an incident on Friday where he was trying to bond out, and we got an email from somebody at the jail about it. Do you recall what I'm?
I don't know what you're talking about.
Oh, I thought it went to the court as well, and it just, I don't know why he's still in jail.
Well, I can assure you that whatever bond issue that existed previously is no longer an issue.
Other case?
Well, I dismissed 25 CF 1754.
Did he pick up another case? Is that what's?
Everything I'm showing is closed.
That's the only case that,
This had to do with count one was apparently a file or something like that. Bill was confused about what the bond was, but I agree. All of that should be solved now. Charges are dismissed.
Paid $3,500 Saturday to clean on bail bonds the bond out. I never got out.
I'll have a copy of the email.
Uh,
Or you can just read it to me, what it says exactly, because,
I mean,
again, I'm looking at the jail's new website, which is different than we're used to. And I clicked on his name, it doesn't list any charges. It says hold, but when I look at the hold reason down at the bottom, it just says Okaloosa County Pretrial Services. So is he being held because he's supposed to be on pretrial services, except his case is dismissed?
It's illogical enough to be accurate.
Makes sense, yeah, as to why it happened.
yeah, that's what I'm looking for. All right.
This is Henry Eugene Jackson.
I don't understand what he paid for.
Well, if he did it on Saturday, that would be the 28th, and I don't think the null pros went in until yesterday, the 1st. So he was trying to bond out. Sounds to me like what he's saying is he
Bond out
paid
in
the
the case
bondsman.
that's been dismissed? Hold on.
So this is from Richard Armstrong.
Hold on a second, let me just mention this. So, at his pretrial detention hearing, there wasn't a pretrial detention hearing. We got a bond hearing, and I issued bonds on each count, which were 9 counts. State files a 5-count information and dismisses counts 1 through 5. My concern is 6, 7, 8, and 9 are somehow holding him even though they were never filed on.
The state would announce that we're taking no action on those counts.
So at this point, let's make sure the record reflects this. Counts 1 through 5 have been null prost. 6 through 9 are no action.
That's correct.
To the extent he's supposed to have any bond on any count, it's an ROR.
Thank you, Judge.
But he shouldn't, because all charges have been dismissed.
What about the money I paid the bail bondsman, $3,500?
I don't know what to tell you on that. I'm not sure why they took money from you in the first place. I legitimately don't know for what he was paying.
So I'm free to go home today, sir?
You should be, but I would like for your lawyer to follow up on it to make sure he actually gets released, because I don't see anything holding him. I mean, there's a mention on the jail's website that says hold Okaloosa County pretrial services. That shouldn't, I mean,
They said I had to get a
how
leg
can that
month
be
to
the
put
only,
on
oh,
my
you know
brother
what it
live.
probably is? Hold on, let me look at it again.
Aggravated assault that came up on me. They said they wouldn't put the leg monitor on because I had 2 counts of aggravated
GPS
assault.
monitor, right?
That may be it.
We could put in the minutes as well. Defendant no longer requires a GPS monitor. Should be released on this case. They shouldn't be, because this case was dismissed.
Tomorrow.
The case wasn't dismissed until yesterday. He tried to bond out on Saturday, which was before the case was officially dismissed as of like 3 o'clock yesterday.
Oh, I understand, but I don't even understand how that was the bond amount he would have had to pay. I don't know, Mr. Jackson. The state dismissed the case yesterday. I'm not sure why you were getting bonded out. You should get out today, but Mr. Williams is going to keep track of that for us.
I am, Judge. I'm trying to set a tickler now, and I'm trying to do too many things at one time.
We talked about that earlier, that phrase, tickler.
I'm just old. I get it. Judge, this is Dominic Lee. Judge, he's got 2 cases. On the one, the first one, it's kind of an interesting legal question. And I talked with the state, tried to get it resolved. I can't get it resolved. It was set plea or continuance. We're going to have to continue it, and I'm going to have to decide whether I want to try it and move for JOA or do a motion to dismiss or just rely on the jury. But all the depots are done in it. It's otherwise ready. We're just disagreeing on what a burglary is.
About the other case. It's relatively new.
Yes, sir. I'm going to move to continue that. I haven't spent nearly time on that I've spent on the old one.
Without objection, Judge.
April 29th, 9 o'clock for pretrial conference. If you're going to file a motion, let's get it done before that.
Yes, sir. All right. Okay. Judge, this is Donald Millison, case number 25 CF 2494. This is another one we're arguing over what the meaning of burglary is. We're not able to reach an agreement on it.
I'm really curious to hear this argument at some point.
Well, on this one, he was trespass warned from a store for shoplifting. He went in during store hours with the store clerk standing there, shoplifted again, and so they charged him with burglary. And so I'm figuring out what my next steps are on it, but
His position is once there's a trespass warning, go inside, you're committing a crime, and you're going in with the intent to commit the crime.
That's the state's position.
So,
I think also burglary can be when you remain in property in order to commit a crime.
And-
For example, if you were to go into a grocery store and hide in the bathroom until they close down, and then
yes, sir.
when the place is closed, that's remaining in.
And that one, I would agree completely. There were a lot of movies on that back in the 70s. Judge, I'll ask for a continuance at this time, though. We're not on the trial docket, and not going to be, it should be ready for trial next time. I really am running out of additional things to do on it.
Well, Mr. Wilson, this case is just from December.
Yes, sir.
29th. The first
they
time
won't
up,
think-
right?
I'm sorry, Judge?
It's the first time up.
Yes, sir.
Mr. Wilson, is there something you want to tell your lawyer?
Judge, we don't have anything to add to that. It was a factual matter about the
I
case.
Understand. All right. April 29th, 9 o'clock.
Thank you, Judge.
But again, if you're going to file any sort of motion on that, I'd like to hear it sooner than that.
Yes, sir. Yeah, I'll be out to see you again. Judge, we're not in agreement on this. Was this set plea or trial, or was it set plea or continue?
I have it on my trial, right?
It was plea or continue because the defense wants to file a motion saying that a knife is not a weapon.
I don't even see. You know what docket number it is?
Oh, it's 25 CF 2337.
No, I can't find it on my paper docket. Oh, there it is. I found it. Yeah, you said it was a possible B motion.
That's correct, Judge. I'll talk with my client some more about it, but at this time, he wants to go ahead and set it for trial, so.
Oh, this is the one where he's allegedly carrying the knife after cutting up
meat, using it for a non-threatening, non-weapon purpose.
He's not charged with cutting meat.
No, he's charged with carrying concealed weapon. Right, but it was a household item being used as a household item, and this isn't the time or the place for the.
I was walking to my house when they pulled me over. I walked from the barbecue down. I had a warrant. The officer said, "Come here." I came. I gave it to him. I was walking from a barbecue.
And Judge, I'm letting him talk because I mean these are all facts that aren't in dispute.
Yeah, I'm not. I was doing nothing wrong with it. Trying to go home.
I've provided witnesses to the barbecue and his use of the knife there. But we're not going to, looks like, resolve it today. Mr. Nichols, I'm going to very seriously consider your request that I file a demand for speedy trial in it, and so it doesn't get continued again, okay?
I'll just make sure I put it. It's being continued, it's at the request of the defendant.
Well, yes, sir.
Y'all set it for plea or continue.
Yes, sir.
Right? You can institute a demand, but
That's what I'm referring to, Judge.
Never had.
You can have the trial. I mean, I can get out subs, it's just cops.
At this point, we don't have the ability to do it. We don't have enough dates.
And I'm not going to be available the first week either because I'll be sitting second chair with Ms. Rivers.
Well, I mean, we can't do it.
Ask you a question.
I can't do it that week because I'll be in the same trial. Yes, Mr. Nichols?
I've never been offered probation, had probation or nothing. And I was willing to take probation because my mom just died. I got a foreclosure in front of you on a whole civil case, and I have nobody out there. I was willing to take probation with the 3 years that you offered as suspended sentence, community control, whatever.
I never did offer
No,
you.
I'm talking about
Okay.
Mr.
He
State's
had
attorney.
turned to the state
Okay.
attorney.
I turned
when he
to
said
state.
that.
When I
willing
looked
to take
back, he was looking
whatever.
at me, that's why I thought he
My
was.
bad. I'm willing to take whatever because I've never even been
What's the
given a
offer,
chance.
Mr. Sprouse?
Adjudication of guilt, 3 years DOC, 515 court costs. And I think it's slightly above what he scores.
No, my score sheet was wrong. Yeah, it's above what I score out to. That's why I asked about the probation. I've never even been offered probation ever. I've always took my time and went in. And I'm willing to take the probation with the suspended sentence so I don't lose all my mama's stuff. I don't plan on getting in no trouble. I didn't know it was against the law to walk down the road with a butcher knife after using it at a cookout. I didn't know this. I dang sure wouldn't have had it.
All right, Mr. Nichols, I would suggest you don't talk about the facts of your case
Oh,
anymore.
it's just plain. I'm not denying that I had it because I did. I just wasn't using it illegally. The law reads it. It's not a deadly weapon unless you use it with the intent of deadly weapon. I never did. I never threatened nobody. I never assaulted nobody. I didn't do nothing with it.
I don't know what you want me to do, Mr. Nichols.
I was just saying the fact.
All right.
Mr. State's Attorney, can I get
Sir, you're
probation?
not going to
Oh, my bad.
negotiate.
No, I'm just asking.
Mr.
why he
Nichols,
won't
can
give
I
me
finish
probation.
one sentence, please? You've
Yes,
cut
sir.
me off the last couple of times. I'm
That's
trying,
it, sir. Sorry, Your Honor.
you have a lawyer. The state attorney's not going to negotiate with you. He's going to negotiate with your lawyer. So you can't just shout back at the state attorney. It's okay. I'm not mad about it. I'm just telling you, it's not going to get anywhere. So, Mr. Williams, file what you're going to file, or set it for trial, or just, unfortunately, it was set for plea or continuance,
Yes, sir.
not for trial. So I know the state's saying they can try to get it together quickly, but at this point, there's not really a day available.
Well, I've got 3 civilian witnesses I'd have to wrangle.
Frankly, the subpoenas aren't out yet, and you're going to struggle to get them,
Yes, sir.
especially for law enforcement witnesses who are, you have to give them 2 weeks. 10 days, isn't it?
10 days.
That's 10?
Last I checked, it was 10 days.
And it's 10 business days? I think.
Yeah, I think so.
I know
2
it
weeks.
I know it just changed.
It's when they actually get served, not,
Within,
substitute service and all that, but I just don't want to try and fast track this trial when I don't have the
which date
days,
they
and you don't
have.
know if you can get all your witnesses on both sides, but
I might talk with you some more. Gave us a clue. Or the next I could be within a month or so. Okay.
Your Honor, can I ask you a question? Not on this matter. It's about my foreclosure.
I can't
right?
talk to you about that, sir.
No, I'm saying,
Yeah, the other
I can't
side
talk
has
to
to
you
be
about that,
present.
sir.
how do
I-
I'm just trying to figure out who I need to write about it.
Whoever sent you paperwork,
He served it to me.
okay, well, you need to read it and respond to who's on there. I can't talk to you about your
Oh,
case,
no,
sir.
I was just, that's why I was, you just.
All right,
answered the
thank you,
question.
Mr. Nichols, 4:29, 9 o'clock.
You gonna file the motion?
Yeah, I'll figure it out, okay? Do- Does Northwest Florida Legal Services still do stuff?
So it depends.
Because he's between a rock and a hard place. I don't know
Can't
that
talk
I
about
even know
cases that
anybody.
are in front of me with other people.
Well, I can't represent him on it, but I'll show him where to look on the paper.